This Honorable Court of Appeals of Tennessee is now in session.
Good morning, Council. Before we start, let me say that we don't anticipate any technology problems, but if we should have any, everybody just take a deep breath and pause, and we'll work through them. Mr. Hibner, call the case, please.
Jennifer King versus Delfasco, LLC et al.
We'll hear from the appellant.
May it please the court, I'm Hank Shelton of the Memphis Bar, and I represent Delfasco and Delfasco Finance in this case. I'm going to address 3 points in this oral argument. The first one is that Delfasco didn't discharge Ms. King for refusing to violate any law or any public policy. Second thing I intend to talk about is that Ms. King could not reasonably have believed that sharing her password was illegal at the time of the firing. And the third thing I'm going to talk about is that in any event, Delfasco didn't violate the Tennessee Public Protection Act, as her refusal to share her password was not the sole cause of her termination. The rest of the arguments I'll leave to the brief or respond as Mr. Harvey may require me to. The key fact, or the key facts rather, of this case are actually set forth in Exhibit A to our brief. That's the string of emails between Delfasco and Ms. King that began on October the 15th and ended on October the 23rd of the year in question. And those emails actually show the exact opposite of a violation of the law. Rather, they show that a low-level employee took $160,000 hostage in a small business where that not insignificant amount of money mattered a great deal, and that all the owner of the company tried to do was get access to the information regarding that $160,000 so that the company could get paid actually on valid invoices. Now, back to item number one, and that is whether or not Delfasco violated the law. That has to do really with the user agreement, which was attached to the complaint and is exhibited in the briefs. Now, that user agreement is 4 pages of government conversation. And in those 4 pages, it lists all kinds of terrible things that the holder of a government password could use and to the damage of the United States. So that the user agreement forbids the holder of the password log information from tampering with government equipment, from conspiring with foreign powers, from sabotaging the government, from committing fraud, all kinds of things like that. The document itself also addresses the question that we're faced with today, that this court needs to deal with, and that is the misuse or abuse or other protections of a password. And that's a little bit different in the user agreement, because what the user agreement clearly provides for is a user should protect her password. And Ms. King was obligated to protect her password, which, by the way, she did not do until the week that we're talking about, really the last 2 days that we're talking about. And it provides, unlike those other sections I referred to, a remedy. So that if someone fails to protect their password, what to do is followed right. What to do follows the actual requirement of protecting the password. Briefly, what it says is protect your password. If it slips inadvertently, you need to do 2 things. 1, let the government know, and 2, reset it with the assistance of the government administrator. Now, let's take that and apply that to the facts we've got in front of us, because that kind of impacts, I think, this whole reasonable belief argument. What happened clearly was that on October 15, Mr. Goldenberg, the president and owner of Delfasco, discovered that he had $160,000 in invoices that weren't paid. So he went to the clerk, Ms. King, the plaintiff in this case, and said, "What's going on?" And he couldn't get a straight answer. as the email string shows. And I might point out that Mr. Harvey, who did an excellent job trying this case, spent a few minutes cross-examining Ms. King about this very string of emails. But the email string indicates that Mr. Goldenberg wanted the information. She didn't get it to him. And she didn't get it to him. And she first said there was one invoice, which is actually what the trial judge found. Then she admitted that there were several invoices. She just made the same mistake on all of them. And then she had computer problems. And the responses by Mr. Goldenberg indicate continuing issues with that. So finally, we get to the last day. And again, I refer the court to Mr. Harvey's excellent examination of his own client, where he was so frustrated that he said, just get me the log information. Now, let's just take a second and look at what she did and what she could have done under the user agreement. What she says she did, and the court credited this, was call some unnamed person in the government and said, can I violate the user agreement? And they said no. And I think that we have to accept that as a finding of credibility. On the other hand, if she just read the agreement, she would have seen what to do, which was let her boss see the information that he needed to run the company, to provide the inventory to the government and get paid for it. And then immediately shut it.
And then what? Reset it?
Yeah, sure. I'm
So
sorry.
she gives him the information, then immediately resets it.
Report it to the government. She'd have to do that. I let my password, I didn't protect my password. Here's what happened. And
Wouldn't
that's all.
Wouldn't that have prevented him from using the password?
No, Your Honor, I would say let him use the password. And then
Well, that's not what the
immediately.
agreement says, though, is it? It doesn't say if the password's gotten out, go ahead and let someone else use it, but let us know after they've used it.
No, Your Honor, what it says is if it gets out, doesn't say anything about timing or other people using it. It says if it gets out, here's how you fix it. So what she could have done was let it out, let him use it, and immediately thereafter fix it. That would have comported entirely with the agreement. The agreement does not forbid her from allowing the company to access its own information.
Well, they would have been accessing the government's information, wouldn't they?
Actually, it was the company's information, Your Honor. The question was, why weren't the invoices getting paid? How should the company fix it so they could get paid? That's the company's information on a
I
government.
understand. What was the login? If she'd have given him the password ability to log in, what would he have been logging into?
He would have been logging into the invoices
Where?
on the government server.
On the government server. Okay.
Yes, sir.
But it does say that if they believe their password PIN has been compromised, they should promptly change their password PIN.
Yes, sir.
So you're saying promptly would be to allow the owner of the company, and I understand his frustration with that the owner of the company to use her password and then change it.
Yes, sir. And report it, of course. Report it immediately. You know, the way I read that agreement and the way I read the federal statute, she doesn't get in any trouble for that. So, you know, the next question is, did she reasonably believe that she would? And let me just address that in the minute and a half I've got left, if I can, Your Honor. And that is really fairly simple. She had never protected it. She kept it on a sticker on her computer. She let her immediate supervisor log into it routinely using that password. And as far as we know from the record before us, when she was fired, that sticker was still there. We don't know that it was. What we do know, and the trial judge credited this testimony, was she had what I would call a religious experience that sharing the password was a terrible thing and she shouldn't do it anymore, so she wouldn't share it. And that's why she didn't share it with Goldenberg.
Well, the trial court found she contacted someone with the government, correct?
Yes, sir. And that's what I just said.
What did the trial court find that what information that person gave her?
The trial court found that person said that you shouldn't violate, you shouldn't let him have the password. That would violate the agreement.
All right. Let me ask you in the 28 seconds you've got left about the whether or not it was your position it was not the sole cause for her termination. Her failure to furnish him the password was not the sole cause for her termination.
Probably the simplest way to put it is this, Your Honor. Had she not covered up her mistaken invoices, we never would have gotten to the point of the termination at all, and we wouldn't be here today. What clearly shows from that string of emails, if I may finish, is that he was frustrated. He said he was frustrated. His attorney, in oral argument on the motion to dismiss the case under Rule 41 at the close of the argument, said he's frustrated. And he was, and he should be. He couldn't get straight information. That's the cause. And ultimately, the refusal to give the password was really the icing on the cake, even if it was illegal for him to ask for it, which of course it wasn't. Thank you, Your Honor.
All right, thank you, counsel. You have your time for rebuttal. We'll hear from the appellee.
Good morning. I'm Joe Harvey on behalf of the plaintiff and appellee Jennifer King. Let me start off by addressing this argument that Ms. King was allowed to disclose her password as long as she promptly changed it. There are two problems with that argument. Number one, there's no testimony in the record to that effect, none. No witness at trial or at any other time in the case testified that Ms. King was allowed to disclose her password under the user agreement. In fact, the testimony at trial was completely to the contrary. First, Ms. Witherspoon, who was the information assurance manager for the Defense Logistics Agency and was in charge of the security of the wide area workflow system at the time in question, 2013, testified that it would be a violation of the user agreement for Ms. King to disclose her password to the president of the company or to any other individual. And that's coming from an authoritative source, the information assurance manager. Second, the wide area workflow representative that Ms. King contacted also informed her that she was not allowed to disclose her password, even if she followed through on these other circumstances. Finally, Delfasco's own expert testified that he would not recommend sharing users' login credentials to another individual, and that a reasonable person would follow the user agreement and not share their login credentials. So there you have three separate independent witnesses who testified at trial who all said that Ms. King was not allowed to do what Delfasco is now arguing she was allowed to do. And I would point out that the argument is based on counsel's reading of the agreement after the fact. And what we're concerned with in this case really is Ms. King's reading and understanding of the agreement at the time based on what she was told. And that goes to her reasonable belief. And that's what the trial court based its decision on, is Ms. King's reasonable belief at the time.
Counsel, let me ask you a couple questions about that. No dispute that she'd shared her password before with her supervisor, correct?
Correct.
Was no dispute that she had it on, was a stickum next to her computer, her password?
There is a dispute about that as to the timing. There's no dispute that at one time she did have her login credentials posted on a Post-it note on her computer. There's a dispute.
I'm sorry, go ahead. I'm sorry, go ahead.
There is a dispute about whether that was available to Ms. Rohr, her supervisor, in October of 2013. Ms. Rohr sent an email the day before Ms. King was terminated in response to an email from Jack Goldenberg. Mr. Goldenberg asked Ms. Rohr, do you have the login information? And Ms. Rohr said, I don't have access. No one in Greenville here has access. So I can't provide that to you. Ms. Rohr said, I can't provide it to you because I don't have it. That was in an email. And Ms. Rohr testified at trial that email was accurate. The argument that Delfasco is now making is based on other trial testimony that Ms. Rohr gave. And the trial court specifically noted in its decision that Ms. Rohr was understandably evasive and that her testimony, testimony was evasive. So the trial court made a credibility determination that the email, the contemporaneous email that Ms. Rohr did not have access to the login information at that time, was more credible than her other trial testimony that the court found to be evasive. The central issue in this case is very simple and straightforward. Did Mr. Goldenberg fire Ms. King because she refused to participate in illegal activity or reasonably believe that she was refusing to participate in illegal activity? And that issue really has two components. One is the reason for Ms. King's termination, and the second is whether she reasonably believed that she was participating in illegal activity. And I'd like to address those issues in order. First, the reason Mr. Goldenberg terminated Ms. King's employment. It's undisputed that Mr. Goldenberg made that decision entirely on his own. No one else was involved. No one else was consulted or even knew about that decision before it was made, including plaintiff's immediate supervisor. The trial court held that the evidence presented at trial clearly and convincingly demonstrated that Mr. Goldenberg fired Ms. King solely because she refused to participate in his unauthorized access to a secure government computer system. The trial court's decision is based on documented evidence that Delfasco could not deny. An email from Mr. Goldenberg that said, "Send me your login information or I'm going to fire you." In response, Ms. King told Mr. Goldenberg that she could not do so because she, quote, was only trying to abide by the rules of the government. Ms. King refused to participate in Mr. Goldenberg's unauthorized access to a secure government computer system. And the next day, following through on his ultimatum, he terminated her employment. The emails were admitted into evidence without objection, and they're very clear in their meaning. They don't require any inference or interpretation. On appeal, Delfasco is asking this court to reverse the trial court's factual findings regarding Mr. Goldenberg's motivation based on emails that do require an inference, that do require interpretation. The trial court's factual findings are given considerable deference, and Delfasco has the burden to show that the evidence preponderates against the trial court's findings. That's a heavy burden, and it's a burden that Delfasco hasn't met in this case. Now, there's been a lot of talk about Mr. Goldenberg's motivation and his reasons for taking the actions that he did. But on appeal, Delfasco is not relying on any testimony that Mr. Goldenberg gave at trial because Mr. Goldenberg did not testify at trial. He didn't even attend the trial. He wasn't there to give any testimony or to say what his motivations were. And on appeal, Delfasco is not relying on any deposition testimony from Mr. Goldenberg because Mr. Goldenberg's deposition was not read at trial. In fact, during his deposition, Mr. Goldenberg did not say that he fired Ms. King because he was frustrated. In fact, he said he did not fire Ms. King. He said that Ms. King resigned, which is hearkening back to this ultimatum that he issued to her, "Send me your password or you're fired," and that she chose to resign. So there's no testimony at any point from Mr. Goldenberg that the reason or part of the reason that he fired her is because he was frustrated. The only clear evidence that's in the record that was presented at trial is the email. And in balancing that email, Delfasco is now asking this court to make two factual inferences. One, an inference that the emails show Mr. Goldenberg was frustrated. And second, an inference that that frustration played a role in the termination. And we would respectfully submit that those inferences are not sufficient to overcome the evidence that was presented at the trial court. The second issue is illegal activities. And having proven that Mr. Goldenberg fired Ms. King solely because she refused to participate in illegal activity, which was his unauthorized access to a secure government computer system, the issue is whether Ms. King was refusing to participate in illegal activity or whether she reasonably believed that she was refusing to participate in illegal activity. Either of those showings would be sufficient for her to establish her claim, and we believe she's established both. But let's start with the reason that was the basis for the trial court's decision. The trial court's decision was correct because the court held, as a factual matter, that Ms. King reasonably believed the activity she was refusing to participate in was illegal. Delfasco
Counsel, I'm sorry, but before you leave that particular part, what did the trial court find, though, or say about her having shared her password before with her supervisor?
Your Honor, I believe what the trial court noted was that although she had shared her password with her immediate supervisor previously, that she learned on October, the day before her termination, that she was not permitted to disclose her password. And that's based on a conversation that she had with a representative of the wide area workflow phone call. It's also based on a conversation Ms. King had with Clyde Mullins, who is a consultant that Delfasco had hired to assist with government contracting issues. Mr. Mullins also told Ms. King, I wouldn't share my password with Mr. Goldenberg. In fact, Ms. King also consulted with her immediate supervisor, and her immediate supervisor said, it's your password, it's your decision. Not, it's the company's password, you need to share it. That's not what Ms. Rohr instructed Ms. King. Ms. King's supervisor said, it's your password, it's your decision. So I think the trial court was looking at Ms. King's state of mind at the time she sent the email saying, I'm only trying to abide by the rules of the government, and found that Ms. King reasonably believed what she was doing was refusing to participate in illegal activity. But in addition to, there is ample documented contemporaneous evidence to support the trial court's finding that Ms. King had a reasonable belief that she was refusing to engage in illegal activity. And that includes the email that Ms. King sent that said, I'm only trying to abide by the rules of the government. But in addition to that email, there's the user agreement that the trial court relied on. And I think it's important to realize that the trial court relied on the user agreement not as a law or a legal principle, but as evidence related to Ms. King's state of mind and her reasonable belief. And that user agreement specifically says that if you violate this agreement, you may be subject to civil, criminal, or administrative action. And Ms. King took that to heart. She believed that she could be subject to those actions if she violated the terms of that agreement.
But she hadn't taken it to heart earlier.
Ms. King testified that she never really even thought about it previously. It never crossed her mind. But when Mr. Goldenberg asked her, it did cross her mind. Because of the things that Mr. Goldenberg had done previously, she had some concerns about what Mr. Goldenberg would do with her password, and so she investigated it. And when she investigated it, she found out these things. She found out more about the user agreement. She talked to a wide area workflow representative. She talked to Clyde Mullins. She talked to her supervisor. And that's when she learned, okay, shouldn't have done that previously. I know that now. And I'm not going to share it with Mr. Goldenberg. And from a legal standpoint, there are a couple of things wrong with Delfasco's argument based on Ms. King's prior sharing of her password. One, from a legal standpoint, the Supreme Court has held that an employee who refuses to continue to engage in illegal activity is protected. So even if an employee has engaged in activity previously, that doesn't establish legally or factually that the employee believes that that activity is illegal. It's also wrong from a factual standpoint because employees do learn new things, and employees can change their minds on things. And just because an employee has engaged in an activity previously doesn't mean that they're forever required to believe that that activity is legal.
Counsel, was there proof presented, or did the trial court find whether or not, if she had shared her password with Mr. Goldenberg, that it would have been a crime?
Yes, Your Honor. Although Ms. King is not a legal scholar, but in addition to her belief, she was right. It would have been illegal for her to share her password because unauthorized access to a government computer system is illegal, actually illegal under state and federal law. That's the Tennessee Personal Computer Protection Act and the Computer Fraud and Abuse Act. Both prohibit unauthorized access to a computer system, a government computer system. And the computer system at issue was not a Delfasco system. It was owned and operated by the Defense Logistics Agency, which is part of the Department of Defense. And that unauthorized access would in fact legally have been a violation of the law.
All right, thank you, counsel. We'll hear from the appellant rebuttal. You need to unmute, Mr. Shelton.
My wife has never told me that.
I can understand.
May it please the court. I think the place we need to start is looking at the user agreement again and what everybody told Ms. King, what Ms. King did. Nobody, including Delfasco, says it's a good idea to breach a contract. Nobody that I know of advises people to breach a contract, but that's not the question here. The question is breaching the contract against public policy or against a law so as to be protected by the Tennessee Public Protection Act? And the answer to that is no. The reason it's not is the contract itself doesn't provide for criminal penalties for the leak of the password. Now that's kind of step one. Step two has to do with whether or not she reasonably believed that that sharing the password was an illegal thing. I think we're all agreed that at the time she shared her password and stuck it on the outside of the computer, which itself is a violation of the user agreement, by the way, that she didn't think it was reasonable, or she didn't think it was a violation of the law. No question about that. The only question is, did she still reasonably think it was illegal at the time she was terminated because of the conversation that she had, according to hearsay testimony, with the WAWF representative? I think the answer to that one is no. And I think the inference now takes us back to those emails. I thought it was interesting that, my very capable opponent addressed my motivations for the structure of my appellant brief. That's what we're talking about, is motives. Now that's just kind of a farcical aside, but the point is trying to figure out whether this was the sole cause requires looking at the entire set of circumstances. And the entire set of circumstances includes absolutely unambiguous, uncontested emails that use the word frustrated, that say, I can't get what I need out of you, that say plainly, I'm not getting paid. You're damaging this company. That's really completely uncontested. And the reason, again, it's uncontested that Mr. Goldenberg wanted access was not in order to do something nefarious. He couldn't do anything nefarious, according to the testimony. All he wanted to see was why his emails, or rather why his accounts receivable had not been paid, and accounts receivable in a very substantial amount. And that information could only be gotten either through Ms. King, who had shown herself to be utterly unreliable at this time on this issue, or from the government directly. And by the way, it's also uncontested, speaking of why she didn't trust him, that it doesn't matter why she didn't trust him, because the uncontested evidence is that he did get a password shortly thereafter. That's in Ms. Rohr's testimony. So her trust or lack of trust of Mr. Goldenberg has no impact at all on whether or not she thought it was reasonably, or whether or not she reasonably thought that it was illegal or even a violation of the agreement to share the password so he could acquire the information he needed to run his company, and that she was keeping him from getting, and had kept him from getting, starting October 15 through the entire week ending October 22nd, when he finally threw up his hands and said, "Get it to me or you're gone." So even if it was illegal, and I don't think it was, then he still did it for a host of reasons leading up to the 22nd, not just for that reason. The other reason, by the way, and let's address just for these last few seconds, the reason Delfasco wasn't getting paid. Delfasco wasn't getting paid, according to Ms. King's testimony, because Ms. King had made the same typographical error on $160,000 worth of invoices. They're all in the record. And that damaged her, and she was covering it up. Again, not a good idea to tell your employee to breach a contract, but that's not why she was fired.
All right, thank you. Court's thanks to counsel for both sides for your briefs and your oral arguments today. Also certainly made your client's positions very clear, and we appreciate that. Mr. Higgins, if you would please recess court until 1:30 this afternoon.
This honorable court is now in recess until 1:30 p.m.